Robinson, go to Nueces County, and the court administrator.
All right. Thank you. Be seated. All right. About that.
Sounds good, Aaron.
Good morning.
Good morning.
My name is David Peoples. I'm a retired judge from San Antonio. And before we get started with this proceeding today, I want to give you some background. The law of Texas very wisely says that when there's a suit to remove a public official, the local judges cannot hear that case. Somebody from outside has to be brought in, and that's wise, I think, because somebody that doesn't know the players is better. I've been a judge for 41 plus years, retired now in San Antonio, as I said, and the Chief Justice of the Supreme Court appointed me to this matter. The law of Texas has allowed suits to remove officials for a long time, more than a century. And the legislature has said that even though a citizen can file a lawsuit to remove a public official from office, before that lawsuit can proceed, the proper public official, which is the county attorney or the district attorney, must join that lawsuit. And obviously the district attorney is subject to this lawsuit, so this is the county attorney matter. The county attorney a few weeks ago, after reviewing this thing, said in writing that she would pursue the case. The law of Texas very wisely says that there's a second gatekeeper. The judge from outside of town has to decide whether citation should be issued so the case can proceed. And that's a discretionary decision with me. And I emailed the lawyers a week or two ago, maybe 3, and said I wanted to have a hearing at which everybody involved in the case could make arguments and present evidence, not live testimony, but written testimony, written documents if they want to, as I can make that decision. And that's what we're here for today. I told the lawyers in that email that I thought a couple of hours would be about the right amount of time. We will go longer than that if we need it. We don't need that much time. We won't take that much time, but that's what we're going to do. And so that's why we're here today. Let me call the case and ask for next. Call number 2023 DCV 0244-G, State of Texas, on relation to Kobe, is it Wilkes or Wilson?
Wilson.
Wilson versus Mark Gonzalez. Passing this term. Ms. Dorsey, how do you now?
Ready to proceed, Your Honor.
Mr. Gonzalez, how do you know?
Your Honor, Chris Gale, I don't know if you received my notice of appearance yesterday.
I didn't, but the bailiff told me that you were here.
I had received, well, I was hired on this case yesterday afternoon, but I'm making an appearance in regards to Mr. Gonzalez. We're ready to proceed, except that we had filed a motion for continuance on two things. One less important and one probably more important. Probably the lesser important for the court is that this thing's been set for a while, and I was filed appeal. Came on board at the 11th hour. I'd need some time to file at least some written documentation. And I do have some concerns with what sort of testimony or evidence would be presented in regards to this hearing. But that aside, from what I understand is that this afternoon, Ms. Dorsey just put an agenda item for Mr. Gonzalez in regards to the Commissioner's Court to make a determination in regards to his representation, since this is brought in his official capacity. I'm sort of here on perhaps one of two ways. Either I'm a short-term representative or I'm a long-term representative, but that's to be seen. So, you know, the reason for the continuance, the more important one is that this is not a typical proceeding. This is a very important proceeding. We're talking about removing a public official who was voted into office by the citizens of the county. And so I would think that determining the representation in regards to that might be important, not only to Mr. Gonzalez, but also to the county. I had conferred with Ms. Dorsey this morning in regards to that issue, and despite the fact that she's the one that placed it on the agenda, and she's the one that would be, I guess, in terms telling the Commissioner's Court or advising them in regards to the very issues concerning this case, including whether I'm going to be her opposing counsel or not. She is opposed to any time to make that happen or to let that happen. So I'm still standing by the motion for continuance in regards to that ground. And then I'll address concerns I have with what type of proceeding and how we would proceed, depending on how the court rules. But that's where we think.
Yeah, we're copying that I can see if you look like it continues.
I did not bring my motion for continuance with me, Your Honor. We literally filed it about an hour.
I do not, but I can have one brought to the court, Your Honor.
I'd like to see it.
I'm looking to see if it's been accepted, Judge. I'm new.
It was just filed probably 4:45, 4:30 yesterday afternoon, and it probably has either just been accepted or accepted. I'm not sure.
Well, I look at my email every morning, and if it was in my inbox, I didn't see it. But I'll read it right now. Yes, sir. You are.
Good morning, Your Honor. My name is Jonathan Houlihan. I'm the attorney for the plaintiff.
While the clerk is getting me a copy of that motion, let me say something about representation of the case. The case law and there's some older cases say that Ms. Dorsey's in charge for the state of Texas, the plaintiff in this case. If she wants your help, she can ask for it and receive it. If she doesn't, that's her call. I do have some I probably could make a decision on that myself, but the law is very clear that she's in the driver's seat. And if she wants assistance from anybody, she can handle that. And if she doesn't, that's her decision. So she's going to be sitting in the front chair. I just wonder if we all change positions. I think we should. Ms. Dorsey and Ms. I want you up here in front. Mr. Houlihan, you can go back to the back.
Yes, sir.
And I'm just going to assume, unless Ms. Dorsey tells me otherwise, that you're here with her permission, and that will be decided later. It's not a problem for me right now. I'd like to read that motion for continuance right now. Yes, did you want to say something?
Yes, sir. I was just going to object to the motion for continuance based on.
Let me read it, and then if I think we need argument on it or discussion, I'll ask for it.
And Your Honor, along that same vein in regards to Mr. Houlihan, and I'm aware of Mr. Houlihan, seems like a really nice guy. We get along, but he is just the water carrier in regards to the petition that was filed in this case by a citizen. He is not representation. Ms. Dorsey is considered that. So any objection from him, while it might be informative for Ms. Dorsey, should not be entertained by the court. not the attorney of record in regards to this case. His job, to the extent that it's done, is done, and Ms. Dorsey is the one in the driver's seat, and I would agree with that, reading the
Kind of what I
rules.
just said a minute ago.
It is, Your Honor, but he's making an objection already, even though you just told him he's not in the driver's seat, so.
Y'all, just Robert, just want to be off the record for a minute and change places.
And Judge, I'd like the opportunity to correct the record regarding the representation and the matters on the agenda in Commissioner's Court today.
Okay.
And at this moment, I can't see it.
You say it's been filed, Mr. Gordon?
It was filed about 4:30 or 4:45, and it was emailed to you
Yesterday afternoon, this morning.
yesterday afternoon. And we sent it to your address that was provided to me by the fifth administration.
Okay, hold on, let's be off the record while I'm getting this straight. I'm gonna look on my phone and see if I can find it. I'll read it. Stand by.
And it's on, a printed copy is on the way from my office, Your Honor. May I approach?
From Amy, Algenstein.
That's my partner, Your Honor, yes.
I didn't recognize that name. I see it. Yes, ma'am, you may approach.
Yes.
Okay, let's be back on the record, but not a lot of talking.
This is the notice of appearance, Judge, with the attached motion and the proposed.
Your Honor, and if I could just say one thing in regards to the motion.
Okay.
When this hearing was actually set, that was when Mr. Gonzalez had asked that something be placed on the agenda regarding the item and the representation. And so it's not quick when you're dealing with a governmental entity, so it was set for this afternoon. We didn't have any hand or face on in regards to that. But
What else do you want to say in support of the motion for continuance of this hearing, Mr. Gale, and then I'll hear from Ms. Darcy.
you know, I mean, apart from the fact that I think it's probably important to determine exactly where this representation is going to lie and for when that's going to continue, if this were to continue past citation issue. But just for me personally, in regards to this case, I mean, I'm pretty good study, I'm pretty quick study, but you know, I'm based on what the court has said, at least in the email that I was provided, was that there was an idea that we were going to have sort of a probable cause sort of motion for examining trial sort of hearing in regards to the issuance of the citation. At least that's kind of how I, reading some of the case law, that's gauged as far as what it is, sort of a gatekeeper type. And the initial impression I got from the emails was that there was going to be evidence, but that evidence was only going to be in the form of documentation. And my concerns in regards to that are, one, that there's a lot of documentation out there that needs to be garnered, some of which I have gotten in the quick time that I've been on this case, and some that I have not. I'm going to be a little bit more involved in order to respond to some of the issues and give it context, so to speak. But the other issue too is that a lot of the things, it's hard to disprove a negative. And so a lot of the testimony or evidence that we would think should be admissible for the purposes of sort of a probable cause determination would come in the form of testimony. Obviously, in the short term, I can give you an overview of what I would offer to the court in regard to that. But I think there's some important people and key issues that need to be addressed. And so that's one of the reasons as well. Obviously, the court can order us how it sees fit in regards to making the determinations. But I think a lot of the issues that are in this case really need to be taken in context, and that context can only be developed for some of them in regards to testimony. So that's the other reason we're requesting that, so that I can accomplish that and make a determination on what I think would be important for the court to hear to issue on the rulings in regards to the probable cause issue or their life.
Ms. Duncan?
Yes, sir. Regarding the issues on the Commissioner's Court agenda, there are two items that are relevant to today. One is the court is going to both hire or ratify the hiring and hear counsel as to their obligation to pay for Mr. Gonzalez's counsel. That is what I placed on the agenda. The other item, as far as hiring or not, Mr. Gale or not, that is not something that I placed on the agenda, but was placed separate and apart from our office.
Thank you. Mr. Gale, on the question of whether to go ahead and have this hearing today or continue component. I understand you're new to the case, but Mr. Gonzalez knew about this. My email was Monday, February 20th, a little bit better than 2 weeks ago. That seems like plenty of time for me. Notice to him, maybe not notice to you.
Well, I believe Mr. Gonzalez was hopeful that the county, I mean, regardless of whether Ms. Dorsey endorsed or filed anything in regards to the cases, the county would have an obligation for indemnification and payment of attorney's fees and some representation during something of this nature when he sued in his official capacity. They have an absolute obligation, so I don't think that's really questioned, but he was hopeful that they would take that action to assign him some counsel to help him and assist him in regards to this, because anybody who comes in here and represents themselves is what? Usually a fool or an idiot. And so you need to have somebody that's your spokesman, and it's the county's responsibility to provide that. So, I mean, I understand that he's known about this, but he has not been assigned any counsel that he's entitled to under the law and under the county's rules. And it's the county that makes that determination. So right now, the person in the driving seat now pushing the petition against him is in the driver's seat in regards to whether or not he gets paid representation and or gets representation at all. So waiting, what would that be? 5 hours for a hearing in which those issues could be meted out does not seem extreme. And when I'm talking about a continuance to do that, for my purposes, I need 2 days tops. But in regards to the issues that are going to be transpiring this afternoon, I don't know. That's up to the county. They're the ones driving this train in all directions. So
speak to the seems to be a fact. I didn't even have to schedule here. I could have just read the thing and decided yes or no. And I've done that before. This hearing was basically as a courtesy to everybody, just to let people be heard. I mean, we didn't have to even have this hearing. You're saying more time so I can be better prepared to find out and get paid by the county and so forth.
I think it's more just to give you the opportunity to take the context. I mean, if you want to proceed with the hearing, then I'll proceed with the hearing. I understand that. I'm just saying what I see as obviously a concern. But if the court wishes to proceed with the hearing, I am adequately prepared to try to do that.
Okay. Anything else by either side that hasn't been said on the
Yes.
continuance issue? The motion for continuance is respectfully overruled. Commissioner's Court will deal with the council questions, and they can do that without any input from me. Now, Ms. Dorsey, I'm going to let you go ahead and stand and present arguments why I'll issue citation. Let us proceed. Mr. Gale, I'll let you do the same thing on the other side of the question, and we'll take it from there. I may have questions, I may not. See how this works.
Judge, may we have 2 minutes? There's a cart of binders that I have for opposing counsel and for the court that's on its way up right now.
Yes. Wait for a couple of minutes more if you need it.
Your Honor, can I step out to get a drink of water?
Let's be off the record and in recess for 5 minutes, okay?
Thank you, Your Honor.
But I'm gonna stay right here.
My name is Melinda. Oh, we're on the. They're using- Yeah. Melinda. Correct.
The dream room.
I think they have. They gave us a thing. May I approach? Judge? These are the binders to the hearing.
Sit up right.
Okay.
Yeah.
IT real quick because I think they're gonna want to use this, and I'm kind of not knowledgeable how to set up that, so we don't have any issue or any more stoppages. I think both of them may. Yeah, we're on. There should be under. Thank you.
We're gonna need the,
Yes, sir, there are video clips to play.
how long do you think you need to roll?
25 minutes. That's at a stretch, Judge.
Do we know? Where to go now?
Did you see?
I turned it on, yeah.
They're on their way. Okay. She's on.
I mean, I'll tell them how to do it. There's a little device that looks like this. It's right behind there. If you plug that into your computer, then your computer connects to that. And you've got to hit the right switch.
We have,
Yeah, basically.
we have the firewall coming up that yours doesn't. So.
Oh,
I'll bow you.
I take it we're waiting for the IT people to get this thing working.
I believe that's the case.
Okay.
Your Honor, in the interest of time, we do have an HDMI cable that we could connect to the computer to the TV if you don't want to.
If it'll work, why shouldn't we do that?
May we approach and try that?
Yes.
Yes, sir.
I'm gonna be expected to see what's on that screen. It's gonna need to be aimed at me a little bit more. For two reasons. One, for the angle, and number two, there's real bad glare from the windows. So, I mean, I think other people will be able to see it too. But turn it back a little bit. Not the other way.
The other way?
And then maybe lower the shades on that second window. Get some blinds. I guess it's a different window. We'll stand in front of that next one. Yeah, that's good enough. Thank you. With the lawyers across the bench.
Judge, these are Facebook videos that the defendant made and posted already to Facebook. They're already out there. And we can skip playing them and I can quote them.
I set it up because I didn't know what they were going to do, and I didn't know how we were going to proceed in regards to whether there be testimony, whether it just be written evidence. So that's why I set it up. I'm still of the same opinion that I think testimony might be important in regards to this case to give it context, especially for the motion for exam trial. So. Oh.
I'm
But if
happy
we-
to proceed without the video,
But if
Judge.
we want to argue on the fourth.
Okay.
And we'll do the same.
Yes.
I'm gonna go ahead without the video. Ms. Darcy, you have the floor.
Yes, sir, may I proceed?
Yes.
What I have tendered to opposing counsel and to your honor are some exhibits for the court to consider, along with a brief set of handouts that is in the front flap, I believe, and a thumb drive that should also be in the front flap. It 1 through 15 is in the handouts. May I have permission to move freely?
Yes, ma'am.
Thank you.
This is 1 through 15.
In the handouts. There's also a table of contents. Oh, that's in the binders. The binders, let me go over the binders. What the binders contain are exhibits both from the original petition and in addition, hearings that were held regarding the Tejeda and the Vasquez murder trial. That is in volumes 1, 2, and 3. And then the remaining exhibits are mostly what was contained in the original petition. We're here, Judge, to recommend, we're in favor of citation. We are moving on incompetency, official misconduct, or failure to give bond. What I want to point out both is that we are using the code definition 870131 and 011. We're here under gross ignorance of official duties and gross carelessness in the discharge of those duties. We're not here to prove that there was evil intent. We're not here to prove a violation of statute. We are here to reiterate that while delegation of duties is possible, it does not relieve the elected official of the duties and responsibilities of his post. And that finally, even with good intent, grossly careless acts can follow.
Your Honor, and I hate to interrupt, but I feel I'd be remiss if I didn't do so. Now that I've been given a copy of this binder that has a plethora, and by plethora, I mean 100 pages of transcripts in regards to some specific cases. I must bring it to everyone's attention that the person that was the subject of the concerns in those cases was Miss Dorsey, who was counsel working for Mr. Gonzalez at the time. So
I have
While in the
no
original-
idea what he's talking
in
about.
the original petition, there was really no mention of these, and there was nothing about these transcripts or any attachment or anything of that nature. But to the extent that we're going to be talking about cases where Miss Dorsey's trial strategies, let's say, came into question in regards to those cases and led to the refusal of the district attorney's office in regards to those cases, I think she has a conflict. I think my client can enforce that conflict and has standing to enforce that conflict. And I think Ms. Dorsey should not be prosecuted in this case. If we're going down these roads that were not contained in the original petition that was filed by Mr. Houlihan and the petitioner. If we're going into other avenues and citing these cases, then again, I'd reurge the motion for continuance, because I would proffer to the court that there are concerns that would lead me to believe that I would at some point be cross-examining Ms. Dorsey in regards to her participation in those cases. So I just don't see how we should continue along these lines if that's where they're going.
Yes, sir. There are two large volumes because there were two cases that were heard where the district attorney and others testified. The one I have provided to the court is the state of Texas versus Joseph Tejeda, state of Texas versus Sandra Vasquez. The Brianna Wood murder occurred sometime in 2016. I have never worked on that case. I was not a prosecutor. The testimony that I've provided was taken on July 15th, July 20th, and August 31st, 30th of 2022. So the things complained of in the petition are this election cycle. The things, the hearing all took place 22 and doesn't have, we're not complaining of things in the previous election cycle. We have not included the transcript from the other case that I believe Mr. Gale might be talking about.
I think that this is exceeding what I had in mind for this hearing. I didn't envision getting too deep into things, but just giving everybody to have a chance to argue, issue citation or don't. I mean, to make their arguments. I did say in my email that, no live testimony, but if you have documents, I'll consider those. I didn't have in mind 5-6 inches, whatever it is, thick. And Mr. Gale has a point. Transcript of testimony. If we end up having a trial in this case, I have no idea what might be admitted into evidence. But at this point, it seems to me where you're wanting to go, is too deep for me. Not what I had in mind. And so why don't you just make the arguments you would make to persuade me to issue citation, and then Mr. Gale can make the same arguments that I shouldn't. Documents within reason, but the content of documents can get us into evidentiary issues, seems to me. So I think I'd rather not go as deep. Yes, sir.
And I just wanted to state my objection for the new exhibits, which literally are about 5 or 6 inches deep. When I said earlier, I'm a pretty quick study, and I am. I can't study 2,000 pages of documents in the matter of 30 seconds. So when I said I was prepared to argue the petition and what was attached to that, I am. But beyond that, I don't know that I am.
And these haven't been offered yet, and certainly haven't admitted them yet.
Yes, sir.
Go ahead, Mr. Archie, but not as deep into the details as I think we're trying to go.
Yes, sir. And
At this point.
at this point, thank you, Judge. And at least 4 inches of this is that transcript. So smart so I can follow the petition. So moving on to the allegations contained in the petition.
By the way, I read the petition. I didn't read every page, every word of the attachments, which was 100 and something pages, but I've read the petition, read through the attachments.
Okay. So I will move on to the Brianna Woods murder case, which is the transcript that was provided. And the reason that is important is it's kind of unique in our, we don't usually have access to that kind of testimony about what happened. So what we will have is more information than we ordinarily would have about what went on in that case. In that case, not only was the victim's mother, Fallon Wood, allowed to come into the office and be alone with boxes, 10, 11 boxes of documents and evidence unobserved. It was not something the VA was aware of. The article, which is also attached, talks about that happening in April 5th of 2021. April 5th, 2021, I believe. That's the community is on notice, the VA is on notice that there is a problem in the office. The testimony starts, and what that would show is this, it's carelessness, it's ignorance of what is going on in the office. So the problem also, see, much of the petition tracks what happened in that testimony. So it's the defendant's failure to provide office insight that we know by the evidence that would be contained in the transcript that was testified to. We also know from the attachment included with the petition that when it was time for the court, when it was time for Board of Judges to meet, asked to meet with the district attorney, he would not make himself available to them either by phone or Zoom when he had to be out of town or in Cabo. And then with the defendant's failure to pursue indictments in support of motions to revoke probation. That's a little bit of a title I would change because what they describe is motions to revoke probation in lieu of prison. Defendants are allowed to have various conditions of their probation. What happened in the first of the two that are described is that the defendant was on for a violent offense, I believe, or not so much a violent offense, but he kept committing new offenses. And every time they're waived a hearing where he could be revoked and put in prison, but eventually he's let out and ends up killed when he should have been revoked. The second one is similar, but not as violent. And it is a pattern that we would bring in testimony and with records in the trial on the matter where motions to revoke as a pattern, they're not revoking people even when it's a flagrant amount and number of relevant violations of that provision. Regarding dismissals, and this is one of the things where I would have brought a video. The allegations in the petition do cite a large number of dismissals relative to previous administration's dismissal. Now, we enjoy, or prosecutors in the state enjoy a lot of prosecutorial discretion. We value that. However, what we have in this case is an admission by the party opponent in his video feed that it's not just justice that he is using to determine how many and what cases to dismiss. Rather, he is using this, I'm going to use the reason of CJIS compliance. We're going to dismiss these cases so that the county gets its money. And what I would have played was part of the Facebook Live where the defendant says, my job as the DA, I shouldn't give two blanks about CJIS. I shouldn't give two blanks if the jail is overcrowded and there are people spilling out. All I should care about is the case I got and justice and nothing else. But then he goes on to say, if everybody, Sheriff, I don't care if you're overloaded. Sorry, Canales, the whole county. He goes on to say, I do care about CJIS. And if I have to dismiss cases so we make sure we get our money, I'm gonna do that. Go ahead, I'll take the hit. So this is one of those issues, Judge, where we say, even if he's having good intentions, you can still have that gross ignorance and that gross carelessness with regard to his duties. And in fact, we would be asking the court to be able to do discovery to find more about the motivation and the numbers and analysis of the dismissals and what, aside from justice and financial reasons, are the motivations for the dismissals. Next, F, defendant's failure to represent the state and ignoring the laws of Texas. Judge, we're unaware of any cases brought to prosecution to the DA's office in that section. So we don't feel we have standing on those allegations, just given his statements and some signed statements with other groups.
Let me say that if or the citation issue in this case proceeds, you're in charge of the minute, please.
Thank you. G, defendant's failure to represent the 105th Judicial District. By law, the district attorney shall attend each term and session of the district, county, and justice courts in Nueces County and shall represent the state in criminal cases pending in those courts. That's his obligation. He can delegate it, but if that delegation fails, he's still got the obligation. It's his. And when the Board of Judges, for one, this is in two parts. When the Board of Judges tries to speak with the defendant and he's not there, they reset it, they try again. That's when you have one of the news articles that I believe is enclosed, where the first assistant is asked, well, where is he? And she says, I don't know. Turns out he was in Cabo because we have the Facebook post after that. The first assistant told the news article, told the people, check Facebook if you want to know where your DA is at. Interestingly enough, that meeting of the Board of Judges was taking place in between two of these, volume 2 and 3, the most high profile case that the office has, and he's just not there. They also complain that they don't have enough bodies to, quote, man the courts. And I would say that that responsibility is not being fulfilled. That goes to gross ignorance and gross carelessness of his duties. Finally, or next to last, H, defendant's misuse of government resources. That's one we would need to do discovery on, but what we do know that is in the videos on Facebook Live, he is in his office, not only in his physical office, but he is cloaked in his office as district attorney and uses that time on Facebook to make announcements about what's going on at the office, interspersed with advertisements for local businesses, for his own business, and in fact, naming defense attorneys and saying to those defense attorneys, hey, if you've got any people that are in jail and are nonviolent drug cases, let me know so we can get them out and get these jail numbers down. So we would need discovery in that to determine what the level of misuse could be. Failure to disclose travel benefits, we would need discovery in that to determine whether we are looking at simple gross ignorance, carelessness, or if it's from misconduct, or both. Finally, regarding the bond, this could appear in two parts. It could be all on its own, failure to give bond. What we believe we know right now is that there is no bond on file with the comptroller today for this term for this DA. Now, it would probably file somewhere else, but it's still even so deficient. But right now today, the comptroller, we don't believe they have any. Not only that, the Secretary of State doesn't have an oath on file for this term either. So that could either fall under the portion that says failure to post bond equals removal, or it could fall back into that overarching umbrella of gross ignorance and carelessness of his official duties. That is from the petition, what we have. We think these things matter very much, Judge. They send a message to the community, not just this community, but the global There's been a lot of publicity for this. I want to make sure I'm not missing anything from the handouts. Oh, also, of course, we have the finding after those 3 days is when Judge Vinales issued the order stating that there was credible evidence of gross incompetence, negligence, and or carelessness on the part of the district attorney's office. And then the articles. That's what we have, Judge. We're asking the court to issue citations so that we can. And we'd ask to enter exhibits 1 through 15 from the binders for the purposes of this hearing.
In regards to the exhibits, I would object to the introduction of the exhibits for the purpose of this hearing concerning issuance of citation. I think they're well beyond it. I think I've expressed the fact that while I'm well prepared to discuss the original petition and whatever documents were attached thereto, which should form the basis of whatever this court would make a decision on, I think anything else is going well overboard, and I haven't even had a chance to review the mountain of information that they provided in these binders.
Be more specific on your objection to the exhibits.
I'm an objector to one, untimely. 2, I would need a continuance to review them. 3, they're irrelevant for the purposes of making a determination by this court as a fact finder in either a probable cause determination or some reason to issue a citation. And they should be limited to the original documents that they produced in regards to their petition, because that is what should support it at best. In addition, I would garner, at least from the pleadings in this case, is that everyone's admitted that nobody, including the petitioner in this case or the county attorney's office, has ever, they keep saying they need discovery, but they have the ability to discover. The Wolf case and other cases directly address this point. They have the right to file a 202 petition under Texas law to get information, to make a determination if they can actually file something to recuse or to remove an individual from an elected position. They have the ability under the 202 petition to get documents that they obviously are lacking in admitting, even in their own argument in support of their petition, and they didn't do that. So I would object to them at this point, using this as an opportunity to either one, try a case that has not been issued citation for, and or 2, that they are relevant for this court's determination in regards to probable cause or their life in regard to the issues of the citation.
Okay, I'm not going to either sustain or overrule that objection, those objections, but I'm not going to consider all of the things in the 2 binders that have been put up here. I think it just goes beyond what I had in mind, and it's too much for this point. I will entertain a lot more discussion if you all want to do it. Do you have anything else to say, Ms. Dorsey, before I turn it over to Mr. Gale?
No, sir.
Mr. Gale, you have the floor.
Your Honor, may I proceed?
Yes.
Real quick, this is not an ordinary proceeding, and the legislature, as the Wolf case and various other cases indicate, this is an extraordinary remedy where you're trying to undo the election. That's exactly what this is trying to undo. It is limited to circumstances, and very limited circumstances, in which someone has either been proven to be incompetent in regards to their job, that have committed official misconduct, or involved in intoxication. I'm assuming by their petition that they're not alleging that Mr. Gonzalez has been intoxicated to any degree that would indicate that he should be removed from office for that purpose, and hence I'm not going to address that. So our argument is limited, their petition is limited to 2 things: incompetency. And during their argument and during their pleadings, they sort of intersperse these ideas. They intersperse gross unfitness, capabilities, and they intersperse these all around there and kind of intermingle them. But specifically, the code provides incompetency is 1, gross ignorance or official duties. In other words, they have to show that the person has no clue what they're doing. They have no idea what their obligations are. They don't know how to try a case. And their own documents, that's just sort of an amorphous term. I'm assuming they're kind of relying on that, but they don't have anything in support for it in regards to their petition or otherwise. They submit applications showing that there's 13,000, 20,000 cases in years that are handled successfully. They don't have any indication that any of those were improperly handled. Their allegations are only in regards to the minutiae cases which are dismissed. That's entirely their complaint. So the only thing that they would possibly have is that they actually had some sort of showing ignorance of official duties, is that he didn't know what to do. And that's exactly the opposite of what they're arguing. They're not arguing an intentional act. They're just arguing some sort of what they say is carelessness. So they don't have anything to support that first part of incompetency. Secondly, under B, gross carelessness in the discharge of duties. And that's where they at least touch on that. And so that's what my argument will basically entail on. Because C is unfitness or inability to properly discharge official duties, which they also argue in there. But that also has to be because of a mental or physical defect that they didn't have at the time they were elected that prevents them from carrying out their duties. That is not alleged. Facts don't support that. So we're not dealing with A or C under the definition of incompetency. And I think the only thing you're basically dealing with is gross carelessness in the discharge of those duties at best. When they talk about official misconduct, which is the second way you can have someone removed, official misconduct is the intentional, unlawful behavior related to your official duties. Okay? And it also includes the neglect, refusal, or failure to perform a duty imposed on other law. And before we get into the particulars, let's make one thing very clear. District attorneys and county attorneys, for that matter, if they handle criminal cases, usually misdemeanors in some counties, they have wide discretion to make a determination on what cases are filed, what cases are taken to the grand jury, what cases are not taken to the grand jury, what cases, even if a grand jury supports it with a bill, what cases they're going to proceed with, what cases they're going to dismiss, what cases they're going to go forward on in regards to capital murder, if they're going to seek the death penalty or not seek the death penalty. There is a lot of discretion, as Ms. Dorsey points out. And it's not just a lot of discretion. It's unbridled discretion in regards to how they determine what cases they're going to file and what cases they are not going to file. And so you cannot sue a district attorney or any other ADA that works underneath them for a decision not to file a case or a decision to file a case. You can't sue them under Section 1983 because of very things that have been delineated by the United States Supreme Court. You can't sue them under Texas law or the Texas Tort Claims Act because it's an intentional act and there's no vicarious liability for that against the state, unless it's the negligent use of tangible personal property, which none of that applies. You can't sue them because they have absolute immunity in regards to that. So with that backdrop, they still, and I say they, this petition was not written by Ms. Dorsey, I understand that. But the petitioner in this case makes these allegations that Ms. Dorsey is now standing behind and trying to support. So I'm going to refer them as her pleadings, since she hasn't amended them, changed anything, or done anything else before this hearing. So let's go to the allegations. And with a little background, Mark Gonzalez started as the DA on January 1st of 2017. He also was reelected and began a second term on January 1st of 2021. And that's important to know because the majority of everything that they cited here has nothing to do with his first term. It has nothing to do with any dates from 2017 to 2021. Nothing. So we can assume by omission that they have no complaints regarding him during that time period. And what's changed? Well, the allegations have changed.
The law forbids them to, it's the court to remove somebody from something that happened before the last election.
I think the law prevents them from taking into account anything for the purposes that's done in your personal capacity before you're elected to office. What I don't think is a matter of evidence to support a long-standing policy and practice, which is what they allege. They put that you have a policy and practice of these things. I don't think anything would prevent them from arguing that that has continued from one set of 4 years to another set of 4 years. But I would agree with you in some respects. In 2012, Mr. Gonzalez had done something. They couldn't use that as a motion to have him removed from office because that was before he was even in office. So let's look at it. Brianna Wood. That's the first thing that they allege here. And the only thing that they really support for is an article that says that the DA's office, in particular the first assistant, allowed one of the, and I don't want to say victim, the victim's mother to look at files to help them in regards to the case. The victim's mother requested the ability to do that. They allowed her to look at some things to see if she could offer some insight that would help them in regards to the case. And the complaints are from everybody is that they allow them to do that. First of all, no one's brought any criminal complaints. And you know why? Because there's no crime there. There is absolutely no requirement that the DA's, well, there's no prohibition for the DA's office to use whatever sources they want to get information in regards to the case. If they want to bring somebody who was killed, their parent in and ask them information in regards to names, who is this person that's listed? What do they know? It says on here, who said this? Would that be true? Do you know this? They can utilize whatever sources they want. They can use the Texas Rangers. They can use CCPD. They can use any outside law enforcement agency. They can utilize witnesses to answer that determination. And so they have put nothing in the petition that shows you any kind of violation of law for anybody in the DA's office for letting her look at a file. And that's what they're asking to do. So when we're talking about that one, they have supported the petition with nothing except some sort of smoke. So let's start off with the smoke and then let's try to create some more smoke on top of that. But in regards to this particular case that they start out with, Brianna Wood, there's nothing there. Their complaint is that they let somebody look at a file. There is no obligation that they not do that. And so they have supported nothing in their petition that would lead to anything that would lead to believe that there was any incompetency or any misconduct in regards to that. In fact, if they were going to argue that that was incompetency, I would argue the opposite, that they're utilizing resources from wherever they may be, especially from the mother of the victim who wants to participate and wants to provide information and wants to help in order to get the conviction of the person that killed her daughter. And so that's not incompetency, that's intelligence. So what they're alleging is that they were intelligent in utilizing the things that are around them. When we go to the next one, well, they didn't address this in their argument, but they do address in the petition, so I'm going to talk about it. And they talk about two cases, Sandra Vasquez and, well, they just mentioned Sandra Vasquez. But in Sandra Vasquez, they talk about, well, the office was recused. Well, that's a misnomer. The office, because of everyone raising concerns that aren't valid, they decided that they would rather recuse and let the AG's office come in and try the case so that it would be clean and there wouldn't be these collateral dramatic issues on the side that would detract from getting justice from this way. That's what happened. They recused themselves in the case and brought in other counsel. There is nothing that would indicate that there should be some sort of citation issue for some kind of violation of law or otherwise in regards to that. And any issues that they may argue exist in regards to evidence or otherwise, they exist in cases all the time. There's 20,000 cases that even they cite that occurred during 1 year, either in the form of being tried, worked out, dismissed. And they want to give you one example of something that's accused that there's evidence missing, but the judge in the order denied it and said that they can't find anything that would lead to any kind of motion to dismiss or otherwise. And so what they're doing again is smoke. It's nothing that would satisfy their burden of proving the two elements in regards to this case, which are incompetency and official misconduct. Now, when we're going all to the oversight, they talk about significant delays in the administration of justice, which is just, I mean, you're talking about a time period. Let's not kid ourselves. If we're talking about a time period, Mr. Gonzalez is trying to keep his office afloat during COVID. That has been a trying time throughout the state. There's been, I think, 25 executive orders at least in regards to those and trying to figure out how we can get things rolling and how we can get trials going. Even the documents they produced in regards to support of their petition indicate that there were like no jury trials during a significant period of time. That's not Mr. Gonzalez's fault. It's not the judge's fault. It's just the time and circumstances, and things are backlogged. And that's why we have overcrowded jails and everything else, and we're trying to accomplish this thing. But when you're talking about this delay, when you're talking specifically the case of Juan Villarreal, they're talking about that one, and they specifically address that Judge Payne granted a motion to dismiss in regards to that case because there was some documents that were allegedly missing. That's the case in which Miss Dorsey and her assistant were involved in at that time, or she was the chief of training in regards to it. But if there was evidence missing, that is for that particular case to make a decision. I would proffer that the public record shows you that the decision in regards to pay on that particular case is under appeal. It hasn't been decided. It's still up on appeal. So They're asking to issue a citation to have a person removed from office for a mistake that his office, including the person that's trying to prosecute it, might have made in regards to the case or might not have made. It hasn't even come to fruition yet. Therefore, it's not even right. Even if that were to satisfy the burden, it hadn't even happened yet. Now, failure to pursue indictments. They have a long, well, they don't have a long, they have half a page and 3 sentences devoted to this topic. And as I told before, and as the law indicates, the law does not require the DA's office to pursue a case. The law allows them the discretion to make a determination on what cases they pursue and what cases they don't pursue. And does the petitioner, does Ms. Dorsey attest anything in regards to the petition as far as support for any particular case that should have been indicted, that wasn't indicted, or a case that was pursued that should have been dismissed? I mean, the complaint is that it wasn't indicted, but they have offered nothing. They offer one case, and it's not even in support of the proposition that they're failing to issue indictments. First of all, indictments are issued by a grand jury, not by the DA's office, and they haven't put anything in the petition that describes any case, whether it was accepted or not, no billed or not, by the grand jury, or what the decision is. But the only case that they offer in, well, I take that back, there's 2. The first one that they cite in support of that is an MTR. It's not an indictment. I mean, it's already been indicted. The person's already on probation. And so they offer an MTR in which they had, it appears that they're arguing that the number one, in other words, whenever you get an MTR, there are certain allegations, failing to pay money, failing to do classes, failing to report, those sorts of things. A number one is a new allegation of some sort of crime that's been committed during that, and the judge will make a determination. They haven't even alleged anything about the MTR, what was taken into consideration in regards to the MTR, why that part was withdrawn, or even if it really was. They don't have anything that concerns it. So they have an allegation that he fails to pursue indictment. And in support of that, the fact that during one MTR that, not Mark Gonzalez, but one of his employees, one of his ADAs, either dropped or did not pursue one particular allegation in that MTR. Keep in mind, Mr. Gonzalez and his office don't determine what happens with an MTR. Their petition alleges that somehow he has the magic button that makes a determination if someone's going to be revoked, if someone's not going to be revoked, they're going to go to prison, or he's going to make a determination regarding it. He doesn't. A judge does. Mr. Gonzalez is not a judge. He brings the evidence that he thinks can support it. He brings the evidence that he thinks his discretion tells him that can support it or not support it, and he withdraws it. We don't even know, or more importantly, you don't even know from the petition or anything else, the real circumstances regarding this MTR. But even assuming everything they say at best value, it means nothing. It's saying that in one particular case, it's probably one of 5,000 that they didn't pursue something. I mean, every MTR is not granted. Every MTR should not be granted. And so, again, they're just using smoke and particular things that they think are going to show that he's not doing the correct thing, but they don't have any evidence to support that whatsoever. The other one that they use in support, and I would say you shouldn't consider this at all, is in May of 2022, defendant declined to prosecute another motion to revoke. So yet again, we're using it as an example of a failure to file a motion to revoke, as an example of not pursuing indictments, which they don't even control. And in regards to that one, all it says is another motion to revoke with a defendant with 3 previous DWI convictions. That's it. The rules under Section 18 of the local government code require that they put with as much specificity as they can in regards to the allegations. They basically put nothing here. I didn't see anything that was ever attached in regards to it. But so again, they're using this smoke. They just want to nitpick in regards to Mr. Gonzalez's, and his office's job on a case that they don't even support it with anything. This doesn't support incompetency or obviously not official misconduct of any kind, because that's not in the definition of official misconduct. Okay, now we're on to the larger portion of the petition, and it deals with the dismissal of cases in total court disposition. What they do strangely is they put this 1 year period between March 21, March 22, and they talk about felony cases that are dismissed, and then they compare it to the prior administration. What they don't do is support and give any credence to these numbers whatsoever or describe them. In regards to any federal litigation, if you were talking about a large number of people or things, you have to have something that describes what the numbers are. You can't just say, wow, there's a lot of cases dismissed, so there must be something wrong. There must be good cases that you just didn't feel like pursuing. None of these things explain if the case was dismissed because it was bad. They don't explain if it was a case that was dismissed because it didn't go before the grand, it went before the grand jury and was no good. It doesn't talk about cases being dismissed because they're part of a felony plea. It doesn't talk about cases being dismissed as part of a plea in another case where someone's going to jail anyway. It doesn't talk about dismissing cases that have been sitting around on their docket. And I proffer to you that if we had testimony, some of the cases have been sitting since 1997 throughout administrations, just sitting and lingering. And the CJIS requirements, in part, do require that we go through and clean these things out. Because if we're going to keep this sort of backlog that he inherited, then you're going to have to make some determinations. You're going to have to make some decisions. And he did. He made decisions. They may not agree with those decisions. They may proffer to this court that those decisions must have been ill-informed or have some sort of carelessness to them. But that assumes something that's not supported by anything in regards to this petition or otherwise. They're decisions. They're decisions that were made during his discretion to make a determination in regards to cases. And they don't support anything in regards to any of these cases that were dismissed. They have not one specific example of anything. And all they've done to try to support a petition to remove an elected official is, wow, there's a lot of dismissed cases. That's it. So even if they were right, even if their dismissals were backed up with some sort of accounting or something to give us some context in regards to why these were dismissed, it wouldn't matter. The discretion lies with the district attorney's office to dismiss them. And if more are dismissed in another county or another predecessor or anybody else, I'm not being rude about it, but so what? It's his discretion to make those decisions. But I proffer, that's not the reason. But in regards to the issuance, in regards to this case, they have supported no evidence in regards to any cases as to why, how, or anything else. And I'd again put on the record that they had, the petitioner and the county's attorney's office had the ability to file a 202 petition. They could have come here and they could have said, you know what, we filed a petition to get this information, and we do have information to support this. And here it is. I garner that they wouldn't get it anyway because there's nothing to support that. But they didn't do that. And so that was their decision. They can't come here now and try to, recreate something that doesn't exist and they didn't try to go get. Now, when we're talking about all these cases, I hear them talk and they say, well, Mr. Gonzalez says, I don't give two blanks. Does he care if the jail's overcrowded? He said he doesn't, and he shouldn't. The overcrowding of the jail is not his responsibility. His responsibility is to make a determination in regards to the cases. So on one hand, they say that he's remiss in his duties because he allows the jail to get clogged. And on the other hand, when he dismisses a case or invites defense counsel to come and talk to him to get people out of jail who are nonviolent offenders, then he's remiss. He's damned if he does, he's damned if he doesn't. Either way, he's making discretionary calls, and there is nothing improper in regards to anything that they're complaining about, except that maybe it's not their management style. Maybe it's not the decisions that they would want to make, but it's not their decision to make, and it's not their management that's important. So he gets to determine how he manages them. And if they don't like that, then they can use the proper remedy, which is run a candidate against them. Run for yourself and have a different management style if that's what your critique is. But so far, there's been nothing to support the petition for the issuance of the citation. On section F, they talk about the failure to represent the state government in the prosecution of cases. In particular, I proffer public record. There is a public record of attacks on any DA, and I'm talking the DA for Bexar County, for Dallas County, for here. There have been attacks upon them because they allegedly are not going to enforce either newly enacted post Roe versus Wade decision abortion laws, and or they're not going to follow or enact things that enforce enactments in regards to children and transgender issues. Ms. Dorsey just got up and said, I put an X on it. She said, we really don't have any cases that have been brought, and that's telling. The petition's been brought saying that he won't prosecute these cases, and regardless of whatever his political inclination might be, they have not cited one case that's ever been presented to the DA's office in regards to either of those issues. So how do they say that he refuses to accept the case if there's never been one brought? Ms. Dorsey just said they have no evidence of any case ever being brought to the DA's office. So that alone, not only, I understand they think they need discovery in regards to it. You know what? Go get something. I proffer they can't do it because it hadn't happened. So they have supported nothing in regards to that. In fact, they kind of acquiesced and sort of knocked it out of their argument when they were talking. So next, failure to represent the 105th Judicial District. Their sole support of that, their sole support is that there was allegedly a judges meeting in which a topic was the DA's office and how they were down on prosecutors. And I think they cited in their brief 13 prosecutors. So there's a meeting in which they wanted to talk about that. Let's put this in context. Mr. Gonzalez is an elected official, just like other elected officials. He cannot summon the judge from the 148 to come to his office and talk to him. He cannot summon the county commissioners. He cannot summon anybody to come talk. He has no power. But the same is true for them. They don't have any right to summon Mr. Gonzalez. Now, I'm not saying they couldn't invite him and maybe he could go, but he was actually on vacation when these meetings happened and he was unavailable. But he sent, like they said, he sent somebody there's dead, Angelica Rodriguez, and she appeared, answered all the questions. So he had somebody appear for him, even if there was an obligation, he has the right to do that. And two, he had no right to be commanded there. So if you have to be found guilty of official misconduct or incompetency, it has to be an official discharge of your duties. What duty was that? To appear before somebody that has no power to make you appear before them? There's nothing there. So their sole support of him failing to represent the 105th, not that he's not supporting them in the 20,000 cases every year that end in whatever form with juries and trials and pleas and all kinds of things, but that he failed to show up at a meeting where they haven't even supported the fact that he was requested to be there. And they haven't supported the fact that he had an obligation to be there or even had to pay them any mind and attend this. So, they fail in regards to that. Misuse of government records. I think I heard Ms. Dorsey say that they really didn't have any evidence in regards to this and they would let us know. I wrote down some notes, but they have nothing to support the misuse of government resources. All they've attached on there are some reports from an open records request that asked if Mark Gonzalez or his first assistant had ever submitted any vouchers for repayment for anything from Nueces County. And you know what the result was? The answer was no. Mark Gonzalez has never requested Nueces County ever pay for anything that he's ever traveled to in his official capacity or individual capacity or otherwise, ever during his tenure as the district attorney. And so I'm not understanding their evidence. They asked Nueces County, please tell us any resources of Nueces County that have been expended for Mark Gonzalez for whatever purpose. And the answer was none. So they're supporting their petition with a lack of evidence and then their argument saying, we really don't have any evidence of that. So I'm not understanding, especially how that would support any allegation of any kind of official misconduct whatsoever. Failing to disclose the travel benefits, again, it's back to the same issue. They have proffered nothing in regards to any benefits that were received by the county, any organization, any outside entity, any company, any individuals. They proffered nothing to the court to show that he's ever received anything or from anybody from anywhere. And yet they say that his financial statements don't show what they don't proffer it should show. And so that makes no sense. Again, they lack complete foundation in regards to their petition. And they're just trying to throw up as much as they possibly can. And so far, everything we've talked about. They presented no evidence in support of a reason for the citation in regards to misconduct or incompetency whatsoever. Now, when we get down to the final issue, the bond, I think this is the one thing that, if true, it might have some merit in it. The problem is, it's not true. And Miss Dorsey, as the custodian, so to speak, of the record for Nueces County, should know better than anybody that Mr. Gonzalez has a bond. And I would offer into evidence Exhibit 1 for the purpose of this hearing. May I approach her?
Yes.
I'll give a copy to Ms. Dorsey, and I'll approach the court as well. Oh, I'll give you the actual one with the exhibit. What I'm going to do is a copy of the bond. It's a packet of paper, but if you kind of look through it real quick, it shows in 2020, after the elections were had, Mr. Gonzalez, along with numerous other public officials that were voted into office, did the same thing that they always do. They go before the county court, the county judges, they do the oath of office. Then they submit, the county attorney submits for their monies to be paid for the purpose of their bonds. And you can clearly see that Mark Gonzalez is on here. The bond was paid for. And you can go through this. He had a bond, period. The only, now, we're going to get caught in the minutiae in just a second. But when we look at the face value, the only reason that they have for the petition, and the only thing that's required is that he have a bond. And so he has a bond. He did have a bond. He's always had a bond. The county paid for it. It was approved by the county commissioners. It was approved through the county attorney's office. Whether it be before Ms. Dorsey or after her, I'm not sure, but he has a bond. They know he has a bond. Now we're getting into the minutiae. I think what their complaint is, and I didn't really hear it, is that it hasn't been filed in the proper place. But one, that doesn't serve as the basis for removal because of that. It's only that you have a bond. And he does. But had Ms. Dorsey checked with the election committee, did come to our attention. I'm marking as Exhibit 2, Your Honor. May I approach?
Yes.
Your Honor, I'm showing you what is a notice of public meeting that occurred in December of 2020. In 2020, as I explained, there would be, they would come before the commissioner's court and they would talk about the approval and everything of that nature. And they would talk about filing the bonds and everything of that nature. And if you look curiously in regards to this notice of public meeting that was created by county attorney's office, Mark Gonzalez's name is the only one of any of the elected officials that's not including in here for filing or of the bond. The only one. Not because of Mark Gonzalez, but because of the county attorney's office. So his name's not included in this. Although he, along with everybody else, is supposed to be included on this. They know he has a bond, they paid for it, everything else. So why did they do that? Well, Mark, this is Exhibit 3, Your Honor. Oh, and just for the record, I'm offering into evidence Exhibits 1 and 2.
Objection?
No objection, as long as I can have a moment to address this issue.
Yes. Both are removed. 1 and 2.
May I approach her? I'm showing you what's marked as Exhibit 3. And this is something after the issuance of this order, Ms. Angelica Hernandez sent an email to the county attorney saying, hey, the county's saying that Mark doesn't have to have a bond, he's not on this thing. And Jenny Dorsey responds and says, well, maybe you already had one in effect. Let me look it up. Let me look into that. So what you have is Ms. Dorsey is aware that, hey, Mark Gonzalez is addressing this. Why am I not on the agenda for my bond? Why is it not being filed? And I'd offer into evidence, Ms. Dorsey has an objection to exhibit 3.
Yes. Objection to the defendant to exhibit 3,
No, Your Honor.
admitted.
Mark as exhibit 4, may I approach her?
Yes.
Showing what's marked as exhibit 4, I would proffer that there was a point in time in which this, unlike the other ones, was not forwarded to the proper authorities by the county attorney's office. And so Mr. Gonzalez and his office made sure that they did in fact have a copy of his bond and sent it to Mary Hand. She is in charge of those things, and so they sent it to TC. So they have one. They have the bond. It was in existence at the time. And if there is any confusion about where it was filed, which is not part of the requirements in regard to, especially for the issuance of the citation for removal of office, if it's been corrected, they know that it was. And more importantly, they've been aware of this the entire time. If they had this knowledge the entire time, then why wasn't it corrected? Why didn't they correct it? Mark Gonzalez did everything he needed to do. Took us up. He got a bond. He checked with the county attorneys and said, hey, why am I not listed on here needing a bond? The county attorneys, I was saying, I don't need a bond. I'll look into it. You know, these are red herrings. And when I say this is the only thing that could have been, if Mark Gonzalez had just said that I'm not getting a bond, I'm not going to follow the law, I'm not going to do any of these things, and yeah, they probably have some merit in having him removed from office, but that's not the case. So he has a bond. They know it. It's been filed with the county for some time now. Here is I'll mark this as exhibit 5. I have a one copy of. I'll give the council a look at the army. I'm showing exhibit 5. It just has the hand stamps that show that it's a certified copy. That show that Mr. Gonzalez's bond has been on file. So as far as argument, I think I just wasted about 15 minutes of mine and the court's time in regards to an issue that I conferred with county this morning, saying, are we really going down this money trail? Mark Gonzalez had a bond. He always had a bond. The requirements that he had a bond, he did. They're alleging his petition, he didn't have a bond. They all fully well know that he does. And for whatever reason, they want to get on here, put on the news that he doesn't have a bond, and he actually did. So without further ado, there is no evidence to support the issuance of a citation in this case whatsoever. And I think I've fully gone through every element of their petition, even those that they tentatively withdrew, I would say. And the truth is that this is an extraordinary remedy. And they don't support anything in their petition except for what are political ideations and differences of opinion and attacks on a specific case here or there in the midst of 20,000 cases every year. And that's it. And they want to utilize this procedure to do what they can do legally, which is in an election year, but they don't want to go through that. And so they're using everything in their power to do that. But there is no reason for the issuance of the citation. I know that this is a probable cause. I use that term. It's a hearing which you can determine if there's reason to go forward. But I think if you look at all the information they provided, and more importantly, the information they haven't provided, they don't have backing for any of these things. And they don't do it under the logical understanding that the DA's office has discretion to make decisions. And I think if you put all the smoke away, the real import of their petition relies upon two specific things. And it's what's been in the news and been the fodder of lots of articles and news stations and everything else. And that's a political division in regards to abortion and transgender issues. That's what this is predicated on. This is the attack that's being made on Judge Crusoe and Dallas, and Gonzalez in Bexar County, and Mark Gonzalez here. Those are the attacks that are being made. And that's the crux of really what they're doing here. And the truth is, they just said they don't have any information to support that. But the very thing that's the impetus for this has no support whatsoever. And the other things are just smoke, they're contrary to the law. They have no support in facts. And Mr. Gonzalez, like him or love him, doesn't really matter. He's the tattoo wielding VA that calls it how he sees it. You know what? That's his management style. That's how he does things. And he calls it how he sees it, and he does things how he sees them to be done. But they have shown nothing to show that he's unaware of his obligations as an attorney or as the GA. They've shown nothing in regards to misconduct or in some kind of incompetency or anything of that nature. And they're just looking at minutia, but they haven't satisfied their burden to allow this court to issue a citation to have a trial in regard to him being removed from office by a citizen's complaint. And there may be valid complaints for removal proceedings. And unfortunately, I would proffer the court, this is just not that one. And this is more about politics than it's about facts. And it's about smoke more than it is about what you actually see and what you actually hear. And with that, I would again proffer that to the extent that the court needed any clarification in regards to the context of any of their exhibits, which I would argue have no basis and have no foundation for the purposes of issuance of citation here, I'd be happy to do that and offer that. Thank you, Your Honor.
Ms. Dorsey, anything in the vote?
Yes, Judge, thank you. I will note that defense counsel doesn't like the binder and the 6 inches of actual documents to supply a basis for the allegations, but supplies new documents of its own. Judge, all of the allegations, or most of the allegations, I should say, in the petition are backed up by the testimony that has been provided for the court. And I am happy to go through, not this flipping, but to point out several times in the testimony where that's backed up. But first, I will address this bond issue. It is deficient. It is here. They have profited themselves. It is not attested to in the oath, which it should be. It is not on file with the comptroller, which it should be. It is not approved by a district court judge, which it should be. And that is the reason why it would not appear on the commissioner's court agenda for approval, because it doesn't get approved by the commissioner's court. Now, noteworthy, defendant came into office at the beginning of 2017. Roughly sometime 2019, he got around to filing the bond for that, but he filed it with the comptroller. He knows it needs to go to the comptroller, and hasn't done that for this round at all. So there it is. It's still not done according to the statute. Regarding go back to my notes. It's not the fact that defendant is utilizing to help further prosecution, Judge. The problem is, and the testimony in volumes 1, 2, and 3 will back up, that there are no guidelines given not only for the handling of evidence, not only for how to lawfully proceed with prosecution. None of that is given to his office. So when he has delegated these duties to his office, he has done so without oral guidance, without written guidance, any of that. And so when those things fail, it is still his responsibility, and he cannot delegate away that responsibility. And so when he frugally allows a victim's mother to come in and have sole possession and unobserved access to documents, exhibits, who knows, evidence, that would be perhaps acceptable if there were some guidelines, if there were some directions. And testimony provided to the court, which we could go over, is that there was none of that. There were no instructions. There were no records of what was there before, what was there after. Not only could a person, and not that person in particular, but the problem is a person in that position could insert things in or could take things out. All of that is addressed. It's not the problem that they're trying to have access for victims. It's that there is no guidance, there is no presence, there is no awareness. He'll testify that he didn't know it was going on, and he probably doesn't know how he would feel about it if he were to address the issue. The problem is that testimony comes way months after the fact that it did happen. He didn't bother to find out how, where, and under what circumstances it happened. Instead, he's careless, he's not present, he doesn't give help to his own office. In fact, in volume 2, the first assistant will, you would read from Fallon Wood's own testimony that in a conversation with the first assistant, she will say, Mark's not here. He doesn't give me any help. I need help. She's crying through this exchange. I need help. And that's when the victim's mother, Fallon Wood, offered to come in and help organize boxes of evidence in her own daughter's murder case. And so those are the types of things, and those are the effects that they have on the community, on the victims.
I'm looking in the petition, not written by you,
Correct.
by Mr. Hullahan, on the general problem of absenteeism.
Yes.
See failure to provide oversight, etc. Okay, go ahead.
What was there something
I just didn't remember how explicitly that was mentioned in the petition.
okay.
So,
Then as far as the absence and the delegation, there are exhibits that do show card swipes, and in testimony at a trial on the matter, we would have testimony from former assistant district attorneys to talk about the effects of that presence or lack of presence on their ability to function in the office. If I can have just a moment, Judge.
yes.
Okay, Judge, just regarding the bond, it's spelled out 42 Government Code 002A, 43002A, and it's right there. It's black and white. It's not been complied with. And whether that in itself, this halfway bond that's not attested to with an oath, this failure to even provide any oath to the Secretary of State, it's here. It's supposed to be payable to the governor. The bond is supposed to be in the sum of $5,000. Has 2 or more good and sufficient sureties. In our case, we have 1 sufficient surety that satisfies that. And it says it's approved by the district judge. It doesn't say it's approved by Commissioner's Court. It says it's conditioned that the defendant is going to, pay on it over any money that he doesn't pay over, that he's received. This is carelessness. This is ignorance of his official duties. It's not a mystery. It's right here. There are instructions on the documents themselves, especially with regard to the oath. Fill it in, send it to this mailbox. He just doesn't care.
Before you sit down.
Yes, sir.
Speak to Mr. Gale's statements about Senate Bill 8, the abortion law, transgender, and that aspect of.
That is one that I reiterate that when I amend it, if given the chance, I will take that out.
Anything else, Mr. Gale?
Yes, just one thing. In regards to the bond issue, their point is he didn't have a bond. He did. They're the ones, and I say, and I'm pointing to Ms. Dorsey, it's her office that gets the bond. It's her office that endorses these. It's her office that takes care of these. It's her office that files these. It's her office that does everything in regards to these. And they're going to come here and say that their carelessness and their ignorance.
I'm gonna
Should
object,
be-
that's just not accurate, Judge. Simply not accurate.
I've heard enough on the bond. What else?
With that, Your Honor, I don't have anything extra.
I'm going to give Ms. Dorsey a chance to replead and come up with her own amended petition. How long do we need to do that?
Could I have 2 weeks, Judge?
2 weeks is exactly what I have in mind. Mr. Gale, whatever happens with Commissioner's Court, let's do this. I want to see what she repleads, what it looks like. And I will decide whether I think we need another hearing like this or not.
Yes, sir.
You don't need to do any work on it before then.
And I'll advise the court of,
That,
and copying everybody, of course, but I'll advise the court in regards to what transpires this afternoon or otherwise.
I think another hearing is needed, and I will let everybody know, and I'll schedule it. We'll wait for a couple of weeks for the amended petitions filed by the county attorney's office. Anything else before we recess?
Not for the state.
Now from the responding, Your Honor.
Thank you all very much for recess.
All right, thank you.
All rise.
I think I'm going to leave these notebooks here.
The court administrator is present. I'm assuming she can probably take it for you if that's what you're.
I'll leave them with somebody. You gather it up.
All right, thank you.
Mind that I did rule on it.